Welcome back to the Rent Roll Queen podcast. I'm your host, Tarsi Taylor. Today's episode is sponsored by Buyer Rent Roll, where deals meet destiny. Navigating rent roll contract terms and conditions can be tricky. Joining us today is Jeremy Streten from NPR Law. Welcome to the show, Jeremy.
Thanks for having me, Tarsi.
Jeremy, can you please introduce yourself?
So my name's Jeremy Streten. I am the director at NPR Law. And we do a lot of rent roll claims and contracts and work with a lot of real estate agents in that industry.
Awesome. So you have a very good idea of what happens with contracts because this is what you do on a day in, day out basis. So today I want to be discussing contract terms, special conditions, because there is such a disjoint in our industry of understanding those legal terms and what actually applies to and what protects a seller and a buyer. Specifically for a seller, because we've got a lot of, business owners that there's different contract terms such as retention, restraint of trade, finance, due diligence, and what actually happens behind the scenes in all of those. So can you just give us a little bit of a rundown? Let's touch on retention first and foremost.
Well, but just before we say that, I'll just say this, that in the real estate industry, especially in Queensland, and I think in the other states too, we get used to a standard contract.
Yeah.
So the REIQ in Queensland developed a standard contract. And so there's this thought that everything's on a standard contract. There is no standard contract for a rent roll sale.
Yes.
I have one that I've drafted. Yeah. Other lawyers have ones that they've drafted, and the terms are all slightly different. So when people see a contract, you really need to make sure you understand what it says.
Yeah.
So I just wanted to make that point at the beginning.
Yeah, I love that.
Because I think there's a misconception out there that, there's a standard contract. And I always get asked, are these standard terms? And it's like, no, there's no such thing as a standard contract. So I just wanted to make that point at the beginning because I think that's important for everyone to
definitely
realise.
Great.
So with retention, that is a big bone of contention, retention.
Yeah.
And it's one where you've really got to be careful about what it says and what the requirements are. So usually there'll be some amount of the purchase price, usually 20%, that's withheld by its seller usually in their solicitor's trust account, and that is to be either paid back to the buyer if they lose properties, so if the managements are taken away, or paid to the seller if they've kept that for a period of time, and normally that's 90 days. So it's a 20% retention for 90 days, and and basically you've got to look at whether or not the buyer loses properties and why they do to be able to make that claim.
Yeah, awesome. And what about restraint of trade? Because that's totally different to retention.
Totally different. So you and I were just talking about this before. The restraint of trade is basically saying that the seller or the seller's directors can't go and compete with the buyer for either the properties that are being purchased or the managements, say in a different in a certain geographic area. So you might say within 5 kilometres of the previous business.
Yeah.
So restraints of trade are very, very different, and they're designed to protect the buyer from losing any other properties to that seller.
It comes down to as well, because there's a lot of agencies where they'll sell off their rent roll, but they're not actually closing the doors to their business. So they're running a sales department, they've got their property management department, they've sold their rent roll, which is their property management department, or they've sold a portion of their portfolio to a buyer. How are they protected during that process through the restraint of trade?
So that's where you've got to be really careful of drafting the restraint of trade in a way that protects the buyer.
Yeah, right.
So a seller in that situation can sell properties, but they shouldn't sell properties from the rent roll because they've sold those to someone else. You can also have arrangements where if they do sell a property from that rent roll, then they pay a certain amount of commission back to the buyer. That there are different ways that you can skin the cat, I guess.
Yes.
But in a general sense, you want to make sure that you're protecting the buyer so that the seller can't go in, sell the managements to them, sell them 100 managements, and then go and sell 20 properties.
Yeah, or take them back. Yeah, because that does. We've both seen it happen where the rent roll is sold off and all of a sudden you've got the seller clawing back at a rent roll, and that's pretty disgraceful first and foremost, but it does happen in our industry, and it's about protecting the buyer.
That's right. And a restraint of trade from a legal perspective is void. In other words, it's very hard to stop someone from actually stopping someone else from doing something in business.
Yeah.
Except where it's to protect the legitimate business interests of the buyer.
Yeah, right.
And that's where you've got to be really careful. And having a just generic restraint of trade, your standard, if we do that term, often doesn't work because it won't be enforceable because it's not protecting the buyer's genuine business interests.
Yeah.
So that's where you've got to make sure it's really well defined and you make sure you're protecting what you want to protect. And normally, as I say, that's the seller can't go and sell properties from that rent roll, that they can't operate a competing business.
Yes.
And there are other ways to do it, but that's the general way to protect everyone.
Okay, well, that's really interesting as well because there's, you just don't really know. And you're putting a lot of trust when you go under contract to make sure, because you're spending a lot of money. It's also the finance issue on that as well, isn't it? So it's very important that as a seller, you actually uphold your word through that process to make sure that you're protecting the buyer who's actually just given you a lot of money in return of managing these properties.
That's right. And as a seller, often they're selling because they're sick and tired of being an agent or they're sick and tired of the rent roll. And so what can happen is a year, 6 months, a year, 2 years later, they can go, oh, actually, I do miss that.
Yeah.
But you've sold the business. You've sold that business. And so you need to honour the fact that that person's bought the business and you need to give them time to do it. There's plenty of other clients out there. There's plenty of other property owners. If you want to, I don't know how many transactions there are in Queensland every day, but there would be thousands, tens of thousands.
Or around Australia.
Yeah. So there's plenty of other fish in the sea and, you can rebuild and do that completely independently if you want to.
Yes.
Just don't attack the person who's paid you a lot of money for that business.
Yeah, that's really important to actually understand that and really, like you said, be honourable in your words so that it doesn't come back. Because once you start the whole process of, like legal battle over this, it could go on for years and it becomes an expensive exercise.
It can. I always sit down with people and advise them of the costs of that. And it's not just the hard money costs, which can be hundreds of thousands of dollars.
Yeah.
It's the emotional toll as well.
Yes.
I actually met with a guy just recently. It wasn't a rent roll, but he'd been in litigation for 4 years. And the emotional toll on him was just immense. And so it's not just the money. And he'd spent like a couple $100,000 on lawyers. And he'd been fighting this and he was losing and he didn't know what to do. And so you've really got to be wary of just fighting it and doing the wrong thing that could end up just costing you time and money.
Yeah, and emotional stress. Because that actually is a killer. And I remember, this is like years ago, there was a resumption matter that had occurred, when they were doing the original Pacific Highway resumptions. And they were doing all of that, and it was a Greek family. I'm Greek, so, and I definitely know all about it. And he basically passed away not long after the win because of the emotional toll it took on them. So that was pretty stressful.
I always remember in one of the last classes in law school is ethics. So yes, they do make us do ethics as lawyers.
Great.
And I remember one of the last things that they said to us, which was the principle of the thing only makes lawyers rich.
Yeah, right.
And so the lesson is if you're just going to fight something on the principle, the only people going to win are the lawyers. And so just take a commercial approach. Do the right thing. Like one of my principles is always do the right thing.
Yeah.
And you'll be fine, and you won't get into those disputes.
Yeah, and then what about with finance, like clauses around finance for purchasing rent rolls?
So I think, in a normal contract, you have like a normal, say, property transaction.
Yeah.
You'll have it subject to obtaining finance approval, and you can either satisfy that or waive that. If you don't get it for a rent roll purchase, and really a business purchase in general, you shouldn't be able to waive that requirement.
Yeah.
You need to be able to show that you can afford to buy this business because there are there's a lot of steps that we need to take of notifying people. And if you can't pay for the business at the end of the day, that can actually destroy a seller's business beforehand. So I think the finance clause is one of the ones that I'm very, very particular on to make sure that there's a proper clause in there that requires them to actually obtain finance. Show evidence of it if we require it, like if there's any doubt, and make sure that the buyer is actually going to proceed. Because as I said, but once we start sending out notices to property owners and tenants saying that the business has been sold, and then all of a sudden they can't afford it. Wow, that destroys businesses if it then doesn't go ahead.
And I think like that's where you've just said it. You've got to have it in writing to say that yes, it's been approved, and now we can go unconditional on the contract because you can't give notice until the contract's gone unconditional. And we've seen it where they're rushing to try and get it across the line, or even on settlement date's been extended by one day for whatever reason. And they're already telling everyone that they've sold the business, but you actually haven't got the money in the bank account.
That's right. That's right. And so you've got to wait till the actual settlement happens.
Yeah.
And as I said, this is where it's different from, say, a property. If you sell a property and the person waives finance approval and they can't settle, well, then you can just go and resell the property. And if there's a deficiency in resale price, and you can go and get that, or you can take the deposit. You lose the value in the business.
Yeah.
And that's not just rent rolls, that's just businesses in general.
Yeah,
I do these all the time. And so, you really want to make sure that you've ticked all the boxes, crossed the T's, dotted the I's, and made sure that you really know that they're going to proceed.
Yeah, it's very, very important to make sure you've got that all in writing, so that, on settlement date and obviously unconditional date, then you can do the communication and keep moving forward, knowing that money's going to come into the bank account as well.
Yep.
And just with regards to due diligence, because due diligence is two different things for a lawyer and for a rent roll due diligence, right? So what's your part in doing due diligence for a buyer or seller?
Our part is really about checking the legal entity that's selling the rent roll. So if we're acting for a buyer, we want to make sure that the seller is properly registered. They've got a proper company. There's nothing against the company that might, that the company's not in legal trouble. It doesn't have any winding up notices against it. We want to make sure that if there are any charges registered over the assets, that we know that they're going to be released. We're looking at things like that. We don't usually get involved in looking at the forms or any aspect of the rent roll, because people don't want, well, it's not our specialty.
Well, that's what I do. That's right. Where I come in.
Exactly.
So you've got two different sides of due diligence. You've got your rent roll due diligence, which is you hire a professional to basically go in and go through all the paperwork management of the portfolio and make sure that they've actually managed these properties correctly and what's mismatched with regards to all their software and, their legal paperwork and so forth. And then you've got yours, where your specialty is, like you said, making sure that the seller is who they say and whatever's going on in behind the scenes. And then you've got all these, when they purchase they're buying the actual company. I don't like that personally. No. I really don't like that. I have seen it go so wrong.
Yeah, so when you buy a company, when you buy the actual company that trades the business, you're buying all of the skeletons in the closet of that business, of that company. So if they haven't paid their super, if they haven't paid their tax, if there's a bunch of claims for negligence, you're taking on board all of those things.
Yeah.
And there's no register of these things. So other than asking for certification from accountants who might lie or may not know, there's actually no way of knowing that. So I always advise not buying the company.
Yeah.
And if we do that, it's a much more painful process. But you can't do it. It's just much more painful. And actually just buy the business, because then you're buying it clean. You don't have any of the debt. And you're usually in a much better position. I
had one client that bought the company, and they ended up with a work cover claim from a couple of years back. So all of a sudden, now they're here it all is, and there's added stress to them that should never have actually happened had they not purchased that company. And sometimes the seller may not even know that might be there. Yeah. Depending on the size of the company and the involvement, they may have no idea that there was a claim in the background. Yeah. And so, much cleaner to just buy the business. And not buy the company itself. And people, the advantage of buying the company is you save stamp duty, for instance. But I think that is offset by the risk that you take. Yeah, there is a much higher risk when taking that. Are there any questions that you wish that a client would come to you when they're asking, when they've presented or they're asking you to draft a contract? It's more around them telling us what their concerns are. Yeah. So, everyone going into a transaction, whatever the negotiations have been, there'll be things in the back of their mind where they've started to think through, I'm concerned about that, or I'm not sure about this. They need to tell us what that is. We can't protect them. Yeah, right. Or we can't make sure that they're covered if we don't know what the concerns are. So I don't think there's ever been a stupid question I've been asked. Yeah. Even though people might feel like it is, if people just ask us the questions, then we can answer them and make sure that we protect them. Yeah, and give them peace of mind realistically, just so that they can go, and then they can go away and think about anything else that they've got and come back to it. I think the contract process, a lot of people try to rush through it. And we have seen ones where they really are drawn out, and that just becomes a pain in the bum for everyone, and it's very silly. But at the same time, you really do need to take your time with getting the contract right that you're very comfortable.
That's right. And you've got to take a commercial approach. You and I have had this conversation before. A lot of my colleagues will ask for changes that really have no real legal effect. Or no real change to the rights of either party. They just want to change the wording for whatever reason. You can probably guess why. And so if that's the case, I always just say, let's just agree to it to get the deal over the line. And so long as I'm protecting my client and there's nothing hidden that the buyer's trying to do that might try and be tricky. We've talked before about clients trying to put things into contracts around retentions, but not just being explicit about it. Just be explicit about it and just put it in there, and don't try and trick people. And you're fine, and the process can go pretty smoothly. But yes, you want to make sure that you're satisfied that you're being protected. Yeah,
it's very important to discuss these things with your solicitor. And they are your A team when it comes to actually buying a rent roll. Like, these are the people that you really need to speak to, and it's so important. And I will always say this, you must deal with a specialist rent roll solicitor, because if they don't understand it, you and I have both seen very poorly settled portfolios, and it will cost you thousands more.
And the time and stress as well of having to try and fix it all.
Yeah, and we talk about burnout in our industry and then they kind of wonder why. Well, it's ask the questions, in the back of your mind.
That's right.
Thank you so much, Jeremy, for coming on the show. I really appreciate your insights.
Thank you so much for having me.